After almost 5 weeks of testimony, the 25 million rand Nulane Investments criminal trial is drawing to a close. On Thursday, the acting judge, Nompumelelo Gusha, ruled on the admissibility of evidence presented during the trial. This as witnesses mostly did not know the original documents' whereabouts or said that they were lost. Does this put the state's case in jeopardy? Well, let's get some perspective now, and we speak to legal analyst Ulrich Roux. Ulrich, thank you very much for your time. Let's put this into context. The state has had to abandon the use of information obtained through the so-called Gupta leaks. That, and along with what I've just said in that introduction, this is the first state capture trial. Is it possibly going to collapse?
Hi, good morning. Thank you for having me. Yes, so if evidence is presented in a criminal trial, then that evidence, there's a certain chain of evidence that must be followed and how the evidence was obtained. We have what we call in criminal law the best evidence rule, and that states that, you know, if it cannot be proven exactly how the evidence was obtained and the chain is not 100% secure when the evidence is presented to court, then the best evidence rule is applicable. And the onus is then on the state to say, well, we obtained the evidence in the following ways. These are the reasons why we cannot produce the originals, or these are the reasons why certain people cannot testify. And the judge or the presiding officer must then decide whether that evidence is indeed admissible or not. You cannot allow hearsay evidence in a criminal trial, and in instances such as this, where you know, evidence obtained by the Gupta leaks need to be presented, the presiding officer must be convinced that the chain of evidence has not been broken, and the best evidence rule must be applied. So it is at the discretion of the presiding officer, and certainly in this instance, the judge found that the evidence presented cannot be relied upon because the chain of evidence has not sufficiently been proven by the state. So certainly a big setback for the state. The next step now is 7 out of the 8 accused have indicated that they will be applying for Section 174 discharge on the next appearance, which is on the 3rd of March this year. And what that would entail is they will bring an application in an attempt to convince the court that the state's case is not strong enough, and that the accused cannot be forced to testify because there's no case that's been made out against them by the state. So one would have to wait and see what the finding is of the court on the 3rd of March, and whether that Section 174 discharge is indeed successful or not. But certainly a big blow dealt to the state, given that a large amount of the evidence that they adduced during the trial thus far has now been deemed to be inadmissible by the presiding officer.
Before we talk about possible reputational damage on the part of the National Prosecuting Authority, let's just interrogate the inadmissibility of that evidence. This is what the acting judge had to say, and that is that the state had failed to authenticate copies of documents that were handed in as documentary evidence in the court. And these documents that could not be admitted include the Deloitte report and the contract between Nulane and the department in the Free State, among others. I mean, that's essentially the strength of the case. If this is indeed where we are, is there any doubt that this case has essentially fallen apart?
Yes, exactly, and that's where, you know, I refer to the best evidence rule. So if the state could only produce a copy, the onus was on them to convince the presiding officer that the copy is sufficient, it has not been tampered with, and it is as good as the original being handed up. And clearly they did not convince the presiding officer of that, and the judge could not sufficiently rely upon those copies being presented to court. It unfortunately does amount to sloppy investigative work by the South African Police Services and placing the National Prosecuting Authority in a difficult position. If that is the only evidence that they could present to court, and that evidence was challenged, as it clearly was by the defence, then there's not much they can do about it but to try and convince the court, in terms of the best evidence rule, that the court should accept the copies and that the originals are simply not available.
Yeah.
I do think that it is very detrimental to the state's case, because a large portion of the case in this matter relies upon those documents, upon the contract that was signed, as well as the Deloitte report. And it is unfortunate, certainly, for the NPA that they could not adduce those original copies. It certainly is a big blow to their case.
Yeah.
Whether that's going to be fatal or not, one would have to wait and see. I mean, it would be irresponsible of me now to make an adjudication on that, and that's why we have to wait until the 3rd of March to see how strong the Section 174 discharge application is by the defence, and whether the judge will rule that the accused will have to, in fact, present their case to court so that an objective decision can be made.
Sure. Ulrich, I mean, I am aware that we cannot draw conclusions on the first case of state capture coming before the courts, but it is the test case. It is the first case of its kind, meaning state capture. If this case collapses, on the one hand, it will strengthen the argument of those who have argued, along with the former president, by the way, but that what state capture are you saying took place? So if such claims do not stand up in court, and yes, it might be through sloppy investigative work, but if this case does not stand up, and perhaps one or two others after it, might people be tempted to draw those conclusions that what state capture was there, even though we know that state capture was concluded upon as having taken place through the Zondo Commission?
Well, one must analyse and break down what state capture entails. It entails acts of corruption and fraud, money laundering, theft. So, terming all of those offences involving state officials and private individuals and private entities using their relationships with state officials to financially gain from it, it should be seen as any other crime being committed in South Africa on a daily basis. And I think it would be unfair to term it as, because this case was not successfully proven, now all so-called state capture matters are not going to be successful. Certainly, it would be, in the NPA's interest to successfully prosecute the accused in this matter, and it would set, the precedent going forward pertaining to so-called state capture matters. But I don't think that society at large and that the NPA or the SAPS must be, not be motivated going forward if there's not success in this one matter. As I said, it should all be seen as cases involving corruption, fraud, money laundering, theft, affecting the state purse, and that they should be prosecuted in that regard. If a crime has been committed or allegedly committed in South Africa, then it must be properly investigated and properly prosecuted in court, and an objective finding must be made. But I think it won't be in anyone's benefit to stereotype all these matters, and because one matter is not successfully prosecuted, that means that there was never any state capture. I think that the Zondo Commission proved, the so-called state capture that has taken place with our state-owned entities, and each matter must be adjudicated on its own merits and based on the evidence gathered in each matter separately.
Ulrich Roux, thank you very much for your analysis there. He is from Ulrich Roux and Associates.